Welcome to Michigan Justice Chronicles with Dan Geherin.
Hello and welcome to Michigan Justice Chronicles with Dan Geherin. Dan is a board-certified attorney in Ann Arbor, Michigan, with over 25 years of experience. He boasts many accolades in the field of Michigan criminal defense and has earned the highest peer ranking available for legal ethics and ability. I am your host, Kevin Rosenquist, and today's episode is Till Death Do Us Part, litigating domestic violence and personal protection order cases. Dan, great to see you again.
You as well. Thanks for the kind words. Thanks for having me. I appreciate it.
Dan, you are a criminal justice attorney. Do you handle family law cases such as divorce or custody?
Thank goodness the answer to that is a resounding no. You know, we are, for lack of a better phrase, sort of a one-trick pony. We only handle cases that have a criminal justice element to it. Now, that's a big tent, right, with lots of different types of law, whether it be driver's license restoration, wrongful death, defending juveniles, defending adults charged with crimes, drinking and driving, college defense. But when it comes to family law and divorce and custody and things like that, never have, never will.
There are some, things that you do handle that are close to family law and criminal justice, and which I mentioned in the opening, the domestic violence and personal protection order. Can you kind of describe those a little bit and tell us a little bit more about what those include?
You know, you're 1,000% right. I mean, when we say we don't do family law, those two areas are probably the closest cousins to family law. The first that you mentioned, DV or domestic violence. These are criminal charges where someone is alleged to have committed an assault and battery or violence against an intimate partner. And then personal protection orders or PPOs, when someone is trying to restrain another person, often someone with whom they have a relationship, from any contact. And so we do a lot of domestic violence work, unfortunately, because that means there's a lot of domestic violence out there. Right. That means that we defend a lot of people that are charged with domestic violence. And then also we do a lot of PPO work, both helping people get PPOs or seek PPOs and then helping people defend. So I'm happy to talk about domestic violence. I'm happy to talk about PPOs and how they're sort of similar to family law, but boy, are they within that criminal justice field.
Absolutely. All right, let's start with domestic violence. What are the elements of a DV charge in Michigan?
Yeah, it's ironic because we all throw around the term, myself included, domestic violence, but in reality, the charge is assault and battery. So if you look up crimes in Michigan, you will see assault and battery. And one of those is if committed against an intimate partner, a spouse, ex-spouse, sometimes children, relationships, then it's considered domestic assault and battery, or what everyone calls domestic violence. The other weird misnomer about domestic violence, it seems like it has to have such violence attached to it. And while there is often violence, sometimes it is a push, a shove, a light tap that can be domestic, quote unquote, violence. So the elements, to answer your question, there must be a relationship, like we talked about before, partner, ex-partner, spouse, and then there must be an assault and or an assault and battery. I won't go into all of the legal machinations there, but that means essentially putting your hands on someone in a harmful, offensive way or threatening to do so. The swing and miss can be an assault, doesn't even require an actual touching. And last but not least, there does not have to be any lasting injury, but if there is injury, sometimes that changes a typical or garden variety, quote unquote, domestic violence to a more serious offense like felonious assault, aggravated domestic violence, so forth, which I'd be happy to talk about as well.
Yeah, what are the types of DV cases in Michigan? Since you brought that up, I'd love to hear what all the types are.
Yeah, and like any other criminal offense, a lot of it depends on record and a lot of it depends on result. So if a person has a criminal history of domestic violence, a pattern for lack of a better word, and they commit another one, the penalties are going to go up. The charge is going to go up that ladder of severity. There's a DV or domestic violence second offense statute, third or subsequent. So it sort of mimics drunk driving in terms of severity with a person's prior convictions. And then there's the result or the intent. If someone puts their hand on their spouse and there is a significant injury, as I mentioned before, it might be an aggravated domestic assault. Then if someone puts their hands on another person's neck, God forbid, we have this charge called assault by strangulation, which is only a relatively new offense. That's a felony. And then you have the worst of the worst cases, people that commit murders in a domestic relationship and so forth. And so the latter analogy, prior history, result, and intent will make that ladder climb depending on what factors are present.
Okay. And what is the arrest? What are the arrest procedures for police responding to DV cases?
Yeah, good question. And every police department's a little bit different, and that's changed over the years. But generally speaking, most police agencies have policies that say if a report is made, whether it's a 911 call or if someone comes in and reports it, and then they see any corroborative evidence, in plain English, they see something to confirm the complaint, they have to arrest. Even if the complainant says, I don't want John arrested, if they said a push occurred and they see a scratch, they see some indicia in the house of upheaval, they see corroborated evidence, they have to arrest. And you'll see videos where police don't want to arrest, but they are bound by their department policy. And the reason for that is, gone are the days where police, I should say, have great discretion. They want to make sure they've covered their own liability. So if they get a report, they take the person to jail. And then typically that person is arraigned in custody within 48 hours. And then, perhaps most surprising to people, no matter their history, no matter what the allegation is, at least in the state of Michigan, in about 95% of cases, that arrestee will be told he or she cannot return home and he or she cannot have any contact with the alleged victim. So the classic example, Kevin, wife pushes the husband, he calls the police, she's arrested. She will be told during the pendency of her case, she can neither go home nor contact her husband, even if they have kids together and so forth. So you ask about arrest procedures in Michigan, that's typically what we see on a domestic violence case.
Oh, wow. Okay. And what are the consequences of DV charge or conviction in Michigan?
Probably heavier than most other misdemeanors. And I shouldn't even say the word probably. There are judges in this state that jail first offenders on domestic violence and are proud of doing so. There are judges that always give people 2 years of probation, which is the maximum under the law, and make people stay on probation for 2 years. Those are the sort of direct consequences of being convicted, along with fines and probation and classes and so forth. Once again, like any offense, though, you have to consider the secondary or collateral consequences. And the big one now is an 8-year denial of being able to possess a firearm. So we're in a state of Michigan that has a lot of hunters and recreational gun owners and people who enjoy their firearms. And if they get convicted of domestic violence, it's going to be about a decade before they ever lawfully can possess again. Then you have collateral consequences like travel. Certain places will not rent to people with domestic violence convictions. Then you have things like immigration concerns and so forth. So there's always going to be those direct and secondary consequences, and probably a little bit more severe on a domestic violence case than just about any other misdemeanor in Michigan.
Have you seen much change in as far as how DV cases are handled or how often they come up since you started practicing 27 years ago?
That's a great question. And I started my career in Los Angeles and sort of on the heels of the O.J. Simpson trial. I was a prosecutor out there, knew a lot of those same prosecutors that went after O.J. Simpson. And that, to me, was sort of the awakening of the American conscience to domestic violence and how it was a crime and not something just behind closed doors. Mm-hmm. And that sort of brought into the justice system this term and this phrase of domestic violence. And I think from there, since then, you've seen many, many, many more cases, not that are occurring, but that are being prosecuted, that are being handled seriously. So that's, to me, the biggest change. Now, you all also have changes in rules, like I just mentioned, the gun prohibition. That's a brand new law in Michigan, 2023. So you have more and more consequences that are occurring every year. You have better training for police and for court staff. And in my view, taking it very seriously and perhaps too seriously, treating every domestic violence case the same when there should be some differences between the person who's a batterer and has a history and that wife who pushes her husband out of frustration that I mentioned. But you sort of get this elephant in the room, domestic violence, all treated the same. So yes, these cases have changed in my career, both in good ways and in bad ways, but they are still one of the most significant and highest volume cases that we see day in and day out.
All right, let's move on to personal protection orders or PPOs. What are the types of PPOs in Michigan? What are the differences?
Michigan divides PPOs into two categories. There's what's called domestic PPOs, non-domestic PPOs. So as you can imagine, domestic PPOs are in that same vein of domestic violence. Someone with whom you had an intimate relationship, and the statute defines that, let's call it wife, girlfriend, boyfriend, husband, someone in your home. So if some relationship goes sour and death no longer does us part, and there's threats of violence or stalking or so forth, the person would seek a domestic PPO. And if the judge felt there was a threat of stalking or there was evidence of stalking or harassment, the judge would put in place a PPO to last for a year to keep those people away from one another. A non-domestic PPO is no relationship. And this is where you typically have neighbors or ex-friends or coworkers who have a falling out, and then they have some idea that they need protection. We see this a lot with neighbors and say, I need to be protected from neighbor Jim. They get a non-domestic PPO, different standard. They have to show essentially a threat of violence as opposed to that stalking harassment. In my view, it's a harder type of PPO to get because judges want to protect the intimacy and protect against domestic violence, a little less likely to grant a non-domestic PPO. But those are the two types of categories in Michigan.
Do you handle both types of PPO work?
We handle both types and we handle both sides, right? So someone might be seeking a domestic or non-domestic PPO and they may come to us to help them achieve that goal. Or someone may say, hey, I'm defending against a PPO against my ex or against my neighbor, and we may defend those. So short answer to your question, yes, we defend both types.
How would somebody apply for a PPO? Do they do it through you or do they go directly to the court?
Directly through the court for the most part. And we can guide them on the forms that they're going to need to fill out, but an attorney cannot apply on behalf of a client in Michigan for a PPO. And often it happens where you're helping them, but the person has to put their own information in there. They have to put the very specific reason why they feel they need a PPO, whether it's domestic or non-domestic. Sometimes they have to attach things, whether it be a police report, a video of the person stalking them, a mean voice message or something. And then they have to file in the court and have the other side served. So typically the courts offer an ex-sheriff or a process server that would do it for $50. They go out and serve the other person so that the other person has a right to potentially defend. But there's paperwork. It's typically done at the court. And then there's a filing requirement so that the other person has notice of the request for PPO.
So when someone comes to you and requests or wants your help requesting a PPO, what do you do for them? What's your process look like?
Yeah, so the first process is to make sure that truly they know what that means. Sometimes people call in anger. I hate my neighbor. I want to get a PPO. Well, let's slow down. Do you understand what this will mean? Do you understand you will be placed under oath? Do you understand it's not a guarantee? So we have to find out what their motives are and what their reasons are. Once they've crossed that threshold, we sort of prepare them for what's next, that they are going to have to go to the court and file. They're going to have their ex or their neighbor or their coworker served with the PPO. And then most likely they're going to have to testify. So if someone is seeking a personal protection order, a judge can grant it what is called ex parte. A judge could just grant it without a hearing, but most often judges will want a hearing. So the person's going to have to be well prepared to testify, give specific examples of why they fear or need protection against the person, and be subject to their own questioning about their own background. So a lot of preparation in terms of motive, what their intent is, and then getting them ready for the process.
Do you handle domestic PPOs requests differently?
I wouldn't say a little differently, but it's a good question because often with a domestic PPO, there's a companion divorce case, right? So someone's going through a divorce, they filed a divorce action, and then they want to get a PPO. So it's often important to work with their family law attorney, make sure that you're not crossing over into that jurisdiction. And oftentimes there's not a need for a personal protection order. Here's my example. If someone's going through a divorce, the divorce judge might issue some sort of informal stay away, or if there's domestic violence, the criminal judge may have issued a stay away order. So a PPO may be redundant and a little unnecessary. So to answer your question very specifically, yes, there's some boxes you have to check with domestic to make sure you're not, crossing over jurisdiction and that it's not redundant, but certainly help people get domestic and non-domestic PPOs.
All right. So how about the other side? Someone comes to you and says, hey, I got this PPO. I think it's a bunch of bunk. Can you help me defend it? What's your process there?
I'm going to pick up right where I left off. The first question is, number one, what have you done here? And if the person, I've threatened them, I've left threatening voicemail messages, my advice to them is save their money, because you're never going to convince the judge you're not a threat or a risk, and I'm not going to take your case, and very few attorneys would. So we figure out what they've done, we figure out what their intent is too. And then, like I said before, is it redundant? Is there a criminal case or a family law case where there's already a stay away order in place? And if so, how much do they care about the piece of paper, quote unquote, known as a PPO? So you sort of go through this checklist, but once you get through those and you realize someone does have, as you said, a bunk allegation against them, then it's getting them ready to testify. Then it's presenting evidence to the judge to show that perhaps they did nothing wrong. And we've defended a lot of these where these neighbor disputes are indeed, as you said, bunk, and convincing a judge why they're bunk and why they're unjustified, because a lot of times, Kevin, a judge's instinct is just to put the PPO in place. Why not? But they have to be reminded these have severe and collateral consequences to someone who has a PPO entered, and remind the judge that there are those consequences that need to be kept in mind.
How often do you see non-domestic PPOs? It seems like I don't know, we all have issues sometimes with a neighbor or somebody. I mean, like, it happens, but like, how often do you see an actual PPO come through?
It is more common now with property disputes, and you have social media. I'll get people who call me and say, I want to get a PPO against this person who's posting all sorts of things about me on social media. And I say, where do they live? They live in California. Well, we're probably not going to be able to be successful here. Maybe you should find an attorney in California. But that's an example of a non-domestic PPO that people often seek. But in my experience, they are tougher to get for the reasons I stated before. And they're not nearly as prevalent as the domestic PPOs when relationships go bad and people break up. That is where you see this onslaught of I need to defend a PPO.
How do PPOs protect the victim, and how do they impact the offender respondent?
Yeah, what we said before, I made a line that they are just a piece of paper. And in some respects, that's true. I mean, a court order is only as good as the person's willingness to abide by it. And you've seen and heard horror stories where someone might have a PPO against them, but that doesn't physically stop them from going to injure or kill the person. So it's not an actual physical barrier. It's a court order that goes into the police law enforcement network to say this person cannot have any contact. They cannot be within X amount of yards from their house. So if the police find Johnny in the driveway of Jane's house and there's a PPO, Johnny's going to jail for contempt of court and probably for new criminal charges. So it protects a location, it protects a person, it gives law enforcement better ability to arrest, but it is largely just a piece of paper. Now, how does it affect someone? A person cannot carry a weapon or own a weapon while a PPO's entered. So you imagine people, again, recreationally are affected. You might have a police officer or a security guard, PPO's entered against them. They can't work and they often lose their jobs.
Yeah.
And although these aren't typically public in nature, they can get wind out there that someone has a PPO. So if you're in the public eye or you have a good job and someone finds out you have a PPO entered against you, it can have those collateral reputation consequences as well.
Yeah, we talk about the collateral damage a lot on this show for sure. Is there a difference between a PPO and a restraining order, or is that just the same thing?
One and the same. Now, sometimes in civil law, you have a restraining order. A company may be restrained from doing something. But in Michigan, typically when you're talking about some act of restrainment, it's a personal protection order in the types that I've described during this podcast.
Okay. Got it. Wow, a lot to unpack there, but definitely interesting and good stuff to know. Well, thank you for joining us on Michigan Justice Chronicles with Dan Geherin. To connect with Dan, head to glgmichigan.com and be sure to like and subscribe our channel and leave us a review if you liked what you heard. Dan, always great to see you. Thanks so much for being here.
Thanks for having us, Kevin. I appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.